Hello, and welcome to California Gun Law. I'm your host, Don Hammond. Today, I'm going to discuss recent updates to California's CCW licensing laws. January 2026 is coming to a close quickly, so let's look at what's new for California concealed carry applicants. We'll check out three topics: changes to the licensing process for all applicants, changes for non-resident applicants, and changes to the disqualifying criteria, and, as a bonus, to the hearing process to challenge a denial. I'm a licensed California attorney and a shooting instructor. I regularly help teach the 16-hour class that's required to get a concealed carry license in California. On this program, we provide education on California's complicated web of gun laws so that responsible gun owners like you can better understand how to lawfully exercise their rights. California has a complicated web of firearms laws and regulations, and there are lots of traps for the unwary. We want to help you do it right so you won't need our criminal defense legal services. Today, I'll discuss current updates to California's CCW licensing laws, including updates for residents, non-residents, and the disqualifying criteria, and what to do if you are denied. First, a bit of history. It's been over 3 years now since the United States Supreme Court issued its decision in Bruin versus New York State Rifle and Pistol Association. That case struck down New York's good cause requirement for getting a concealed carry license. California had a similar good cause requirement, which was therefore invalidated as well. California at the time also had a good moral character requirement to qualify for a CCW license. There was some litigation in 2023, including a case called People v. Mosqueda from California's 3rd District Court of Appeal, which took issue with the good moral character requirement. Ultimately, beginning January 1st, 2024, with the implementation of Senate Bill 2, the good moral character requirement and the good cause requirement were both removed from Penal Code sections 26150 and 26155. Those same changes in Senate Bill 2 also made California a shall issue state if an applicant meets the listed requirements. It is now easier than ever to get a CCW license in the state of California, and I encourage people to apply. I have other videos on this channel about the application process and requirements, and the court hearing process in case of a denial, so this will serve as sort of an update. I've handled a bunch of those hearings throughout the state for people who are denied, and several of them over just the last few weeks. New for 2026, there have been a few changes in the application process, mostly brought about by Assembly Bill 1078, which took effect on January 1st, 2026. The biggest change for California's residents is interesting. Penal Code section 26202B1 no longer requires an interview for in-state residents applying for CCW licenses. I think most agencies will still conduct interviews, but they're not required to. And interviews can be done virtually or telephonically if the agency chooses to do them that way. Another big change for everyone is in the amendments to Penal Code section 26195, which mandates that agencies shall not issue licenses to any applicant who knowingly provides incomplete or inaccurate information on the application. It's interesting that that was not explicitly laid out previously, but now it's clear that anyone who is not completely honest on the application is going to have a tough road. Because also the expedited hearing process laid out in section 26206 does not apply to a failure to disclose denial, because that denial is not pursuant to 26202. So if you're denied for failing to provide complete and accurate information, you'll have a much more complicated path to challenge whether that failure was knowingly done and whether in fact you failed to disclose anything. I was just speaking with a guy today who I didn't think failed to disclose anything that would be responsive to any of the questions on the application. But the issuing agency believes that he should have included that someone made a police report against him, even though he was never even contacted by the police about the incident. I don't think he provided incomplete or inaccurate information, and if he did, it certainly wasn't done knowingly. But challenging that will be a complicated process. For non-residents, good news. Sections 26.150 and 26.155, which lay out the basic shall issue framework for California CCW licenses, now include non-resident licenses right there in the statute. There's no longer a need to show that you're a member of specified organizations, which was previously required under the court orders in CRPA versus LASD and the Hoffman v. Bonta case. The same shall issue framework applies to non-residents as to residents. The only additional requirement is that you have to attest that the agency where you're applying for a CCW license is the primary place where you plan to visit in California. Be careful on the application because the same failure to disclose exclusion applies, and the disqualifying criteria in 26.202 have been updated to include out-of-state convictions and restraining orders. The law was also clarified that non-residents who are denied under the disqualifying criteria in Section 26.202 can request a court hearing to challenge that denial in the county where they applied. It used to say in their county of residence, which would be absurd for a non-resident, even though I had a DA make that argument in one of my hearings. And that's the final topic I want to discuss today. Changes to the disqualifying criteria in Section 26.202. First, the good news. The law previously disqualified you for 5 years if you were subject to any restraining order. Now it is clarified that the disqualification does not apply if you were not given notice and an opportunity to be heard before that restraining order was issued. So temporary orders, which judges give out like candy, are no longer disqualifying unless there's a final order issued after a hearing. Other parts of 26.202 were updated to include out-of-state equivalents of various California restraining orders and convictions. So before you apply, review the disqualifying criteria in 26.202 carefully to make sure that none of them applies to you, and consider getting your own live scan before you apply so that you can see exactly what's on your record, because you don't want to get caught forgetting about that arrest from 30 years ago. I see this way too often. The most broad and subjective reason for denial is still reasonably likely to be a danger to self, others, or the community at large, and that is often the result of a not-so-stellar psychological evaluation. Yes, the agency can still send you for a psychological evaluation as a part of the process. Another criteria that can be problematic is has engaged in the unlawful or reckless use, brandishing, or display of a firearm. That's not time-limited, which I think begs for a constitutional challenge under the Supreme Court case Rahimi. Some agencies are denying everyone who has ever been arrested for carrying a gun without a license. That seems like an overbroad application of the disqualifying criteria. And if you are denied for one of these reasons under Section 26.202, both residents and non-residents are entitled to request a hearing in the county where they applied. That's a court hearing. You must request a court hearing within 30 days of the denial, and then the court has to set a hearing within 60 days of when you file your request for hearing. At the hearing, a district attorney, a prosecutor, has the burden of proof to show that you are a disqualified person under the statute. Now, I know that some people resist the idea that they need a license to carry a gun, but the penalties for carrying in California without a license can be steep, including loss of your Second Amendment rights for 10 years. And there are benefits to having the license, including waiver of the firearm safety certificate requirement when you purchase a gun, and exemption from the laws that prohibit carrying concealed firearms and loaded firearms under various California Penal Code sections. Plus, when more of us get licenses, we show the government that it's not just some fringe segment of the population who's interested in gun rights. There are a lot of us, and I think it's important for the government to know that. Some of the slower agencies seem to be improving their application processing speeds, so let us know in the comments how long your application process took and which agencies seem to be the fastest. And head on over to cagun.law for legal updates and to pick up some cool merch to support the cause. I'm Don Hammond of California Gun Law, and we'll catch you all next time. Stay informed, stay legal, stay safe.